You have been waiting for years, stuck in the immigration system, watching your dreams of living permanently in America slip further away with each passing month. As your visa application sits in limbo, your green card priority date barely moves, and you feel like the system has forgotten about you. But what if I told you that January 2026 is bringing a wave of major relief for immigrants that could finally open doors that have been closed for far too long? With changes coming that could dramatically speed up processing times, reduce backlogs, and give millions of people the hope they desperately need. This is not hype, this is real, and if you are caught up in the U.S. immigration system or planning to come to America, you need to hear this right now, because what happens in the next few weeks could change your entire future. Welcome to U.S. VisaPortal, the channel where we bring you the most critical updates on immigration visas, green cards, and everything affecting immigrants and visa applicants across the United States. I am here to make sure you stay informed about the changes that matter most to your immigration journey. Today, we are talking about the major immigration relief measures that are taking effect in January 2026 and how they could impact millions of immigrants, workers, students, and families, whether you are waiting for a green card, dealing with visa delays, or hoping to bring family members to the United States. These updates are exactly what you need to know, so make sure you subscribe to US VisaPortal, hit that notification bell, and stay with me until the end, because this information could be the breakthrough you have been waiting for. Immigration in the United States has been characterized by delays, backlogs, and frustration for years. Millions of people are stuck waiting for their applications to be processed, with some facing wait times of a decade or more. Families are separated. Workers cannot change jobs. Students face uncertainty about their status, and the entire system feels broken. But starting in January 2026, a series of reforms and policy changes are being implemented that promise to bring significant relief to those caught in the immigration maze. These changes are the result of legislative action, executive orders, and administrative improvements, and they represent the most substantial positive shift in U.S. immigration policy in many years. Let me break down the key areas where relief is coming and how each one could affect you. The first major change involves the processing times for employment-based green cards. For years, highly skilled workers, particularly those from countries like India and China, have faced crushing backlogs in the EB2 and EB3 employment-based green card categories. Some applicants have been waiting for 15 or even 20 years for their priority dates to become current. This has created a situation where talented professionals are trapped in temporary work visa status, unable to change employers freely, and facing constant uncertainty about their future. Starting in January 2026, USCIS is implementing a series of measures designed to dramatically reduce these backlogs. First, they are significantly increasing staffing levels dedicated to processing employment-based green card applications. Additional immigration officers are being hired and trained specifically to handle these cases. Second, they are implementing new technology and streamlined procedures that will allow applications to be processed more efficiently. This includes expanded use of electronic filing, improved case management systems, and automated processing for straightforward cases that meet all requirements. Third, and perhaps most importantly, the per-country caps that have been the primary cause of the backlogs are being reformed. While they are not being eliminated entirely, the way unused visa numbers are allocated is changing to allow more applicants from high-demand countries to receive green cards each year. This means that if you are from India, China, Mexico, or the Philippines, and you have been stuck waiting for your priority date to advance, you could finally see meaningful movement starting this year. To elaborate on this point, the long-standing issue with per-country caps has disproportionately affected applicants from populous nations, leading to unequal wait times that do not reflect the merits of individual cases, but rather the accident of birthplace. By adjusting how unused visas from other countries are redistributed, the system aims to create a more equitable flow. potentially advancing priority dates by several years for those in the most backlogged categories. This reform acknowledges the contributions of skilled immigrants to the U.S. economy and seeks to retain talent that might otherwise be lost to other countries. Furthermore, the increase in staffing is not just a nominal addition but a targeted effort to address bottlenecks in adjudication, with new hires undergoing specialized training to ensure they can handle the complexities of employment-based petitions efficiently. The technological upgrades are equally critical, as the shift to electronic filing reduces paperwork errors and speeds up initial reviews, while automated systems can flag complete applications for immediate approval. Bypassing manual checks where possible, all of these elements combined could transform the employment-based green card process from a multi-year ordeal into a more predictable and timely pathway, offering relief to professionals who have invested their careers in the United States. The second area of major relief involves family-based immigration. Millions of U.S. citizens and permanent residents have been waiting to bring their family members to the United States. With some categories having wait times of over a decade, the new reforms increase the annual cap on family preference visas, which means more people will be able to immigrate each year. Additionally, certain categories, particularly the F2A category for spouses and minor children of permanent residents, are seeing priority processing, which will significantly reduce wait times for immediate relatives of U.S. citizens, which includes spouses, parents, and unmarried children under 21. The changes are even more dramatic. USCIS is committing to processing these applications within 6 months of filing for cases that are complete and straightforward. This is a massive improvement from the current processing times, which can stretch to a year or more. For families who have been separated, this means they could be reunited much sooner than they ever expected. Delving deeper into this, the expansion of family preference visa caps addresses a fundamental humanitarian aspect of immigration policy. Recognizing that family unity is a core value in American society, by allowing more visas annually, the reforms aim to clear out long-standing queues that have kept siblings, adult children, and other relatives apart for unreasonably long periods. The prioritization of F2A cases underscores the importance of supporting permanent residents in building stable family lives, while the 6-month processing commitment for immediate relatives represents a bold step toward efficiency, ensuring that straightforward cases do not languish due to bureaucratic inertia. This timeline improvement is supported by internal reallocations of resources within USCIS, focusing on high-volume family petitions to minimize disruptions to personal lives. Ultimately, these changes could alleviate the emotional and financial strain on families, enabling quicker reunifications and fostering stronger community ties. The third major area of relief involves work authorization for certain categories of immigrants. One of the most frustrating aspects of the current system is that many people who are legally in the United States and waiting for their green cards are restricted in their ability to work or face long delays in receiving their employment authorization documents. Starting in January 2026, automatic work authorization extensions are being expanded to cover more categories of applicants. This means that if your EAD is expiring and you have filed for a renewal, you will automatically receive an extension of up to 180 days while your application is processed. Additionally, spouses of H-1B visa holders who hold H-4 visas are seeing expanded work authorization eligibility. While some H-4 spouses have been able to work in recent years, there have been restrictions and uncertainty. The new rules clarify and expand this eligibility, making it easier for H-4 spouses to obtain work permits and contribute to their family's financial security. This is huge news for the thousands of families where one spouse is the primary visa holder and the other has been unable to work. Expanding on this, the automatic extensions for EAD renewals address a critical gap that has often left individuals in precarious financial situations, unable to maintain employment during processing delays. By broadening the categories eligible for these extensions, The policy ensures continuity in workforce participation, which benefits both immigrants and the broader economy. The clarifications for H-4 spouses remove ambiguities that have deterred many from seeking work authorization, streamlining the application process and reducing approval times. This not only empowers accompanying spouses, but also helps retain high-skilled H-1B workers by alleviating family economic pressures. Overall, these measures promote self-sufficiency and integration, reducing reliance on single-income households in immigrant communities. The fourth area involves student visas and OPT optional practical training extensions. International students are a vital part of the U.S. economy and education system, but many have faced challenges in transitioning from student status to work status after graduation. The new reforms extend OPT periods for STEM graduates and create clearer pathways for students to transition to H-1B work visas or other employment-based immigration categories. Additionally, processing times for student visa applications and extensions are being prioritized to ensure that students can maintain their status without unnecessary gaps or complications. To provide more context, the extension of OPT for STEM fields acknowledges the specialized skills these graduates bring, allowing them longer periods to gain practical experience and contribute to innovation-driven sectors. The clearer pathways to H-1B visas streamline what has been a competitive and uncertain lottery system, offering more predictable options for retention of talent educated in U.S. institutions. Prioritizing processing for student-related applications prevents status lapses that could derail academic and professional trajectories, ensuring seamless continuity. These reforms underscore the value of international students in enriching cultural diversity and bolstering economic growth through knowledge transfer. The fifth major relief measure addresses humanitarian immigration, including asylum seekers, refugees, and those seeking protection in the United States. The asylum system has been overwhelmed with cases, and many legitimate asylum seekers have been waiting years for their hearings. Starting in January 2026, additional immigration judges are being deployed, and new streamlined procedures are being implemented to process asylum cases more quickly. While this does not mean that all cases will be approved, it does mean that people will get hearings sooner and will have clarity about their status, rather than being stuck in limbo for years. For refugees, the annual admission numbers are being increased and processing procedures are being improved to allow more people to be resettled in the United States. This is particularly important for people fleeing conflict, persecution, and humanitarian crises around the world. The new measures also include improved support services for refugees once they arrive in the U.S., including assistance with housing, employment, and integration into their communities. Examining this further, the deployment of more judges targets the judicial backlog that has prolonged uncertainty for asylum applicants, with streamlined procedures focusing on efficient case management without compromising due process. This acceleration provides timely resolutions, enabling successful claimants to rebuild their lives sooner. The increase in refugee admissions reflects a commitment to international obligations, enhancing processing to expedite resettlements for those in dire need. The enhanced support services address post-arrival challenges, facilitating smoother transitions through targeted aid in essential areas like housing and job placement. Collectively, these initiatives strengthen the humanitarian framework of U.S. immigration, offering protection and stability to vulnerable populations. The sixth area of relief involves reducing the administrative burden and complexity of the immigration system. USCIS is rolling out improved online filing systems that will make it easier to submit applications, track case status, and communicate with immigration officers. The infamous request for evidence or RFE process, which has been a source of delays and frustration, is being reformed. USCIS is committing to issuing fewer RFEs by providing clearer guidance upfront about what documentation is required, when RFEs are necessary. The response times and processing procedures are being expedited. Additionally, there is relief coming for people who have made mistakes or have technical issues with their applications. The new policies emphasize fixing problems rather than automatically denying cases. For example, if you filed an application with a minor error or missing document, USCIS will give you an opportunity to correct it rather than immediately rejecting the entire application. This common-sense approach will save thousands of applicants from having to refile and pay fees again to deepen the understanding. The upgraded online systems represent a digital transformation aimed at user-friendliness, reducing paper-based inefficiencies and enabling real-time interactions. The RFE reforms shift toward proactive guidance, minimizing unnecessary back and forth by clarifying requirements at the outset and accelerating resolutions when additional information is needed. The emphasis on corrective opportunities over denials promotes fairness, acknowledging that minor oversights should not derail otherwise valid applications. This approach not only saves time and resources for applicants, but also for the agency, fostering a more collaborative immigration process. The seventh major change involves fee structures and financial relief. Immigration application fees have been a significant burden for many families, particularly those with limited financial resources. While fees are not being eliminated, the new rules create more fee waivers and reduced fee categories for low-income applicants. If you can demonstrate financial hardship, you may be eligible to have certain fees waived or reduced. Additionally, payment plans are being introduced for some of the more expensive applications, allowing families to spread the cost over time rather than having to pay everything up front. Elaborating on this, the expansion of fee waivers and reductions targets equity, ensuring that economic barriers do not prevent deserving individuals from pursuing legal immigration pathways. By requiring demonstration of hardship, the system maintains integrity while providing access. The introduction of payment plans alleviates immediate financial pressures, making high-cost applications more manageable for working families. These financial adjustments recognize the diverse socioeconomic backgrounds of immigrants, aiming to make the system more inclusive. Now you might be wondering how these changes will be implemented and whether they will actually deliver the promised relief. It is a fair question because we have seen immigration promises before that did not fully materialize. However, there are several reasons to be optimistic about these particular reforms. First, they are backed by both legislative action and administrative changes, which means they are not dependent solely on executive orders that can be easily reversed. Second, significant resources have been allocated to support implementation, including hiring thousands of additional USCIS staff and investing in technology infrastructure. Third, there is strong bipartisan and public support for many of these measures, particularly those that reduce backlogs and improve efficiency. Even people who disagree on broader immigration policy generally agree that the current system is broken and that people who are following the rules and waiting their turn deserve better treatment. Finally, USCIS and other immigration agencies are being held to clear performance metrics and timelines, which creates accountability and makes it more likely that the promises will be kept. To provide more insight, the combination of legislative and administrative backing ensures durability, as laws provide a stable foundation, while agency adjustments allow for flexible execution. The resource allocations are substantial, with staffing increases directly addressing capacity issues and tech investments enabling scalable improvements. Bipartisan support reflects a consensus on systemic flaws, transcending political divides to prioritize practical solutions. The accountability through metrics ensures measurable progress, with timelines enforcing timely delivery. All these factors bolster confidence in the reform's effectiveness. So what should you do if you want to take advantage of these new relief measures? First, if you have been delaying filing an immigration application, now is the time to move forward. With improved processing times and clearer procedures, your chances of success are better than they have been in years. Second, if you have a pending application, make sure all your documentation is complete and up to date. The new systems will prioritize cases that are ready for decision, so having everything in order will help you move through the process faster. Third, take advantage of the new online tools and resources that USCIS is rolling out. Create an online account if you have not already done so, and use it to track your case status and receive updates. The more you engage with the system proactively, the better you can stay on top of your application and respond quickly if anything is needed. Fourth, consider consulting with a qualified immigration attorney, especially if your case has any complexity or if you are unsure about the best path forward. The reforms create new opportunities, but navigating them still requires expertise, and the cost of a mistake can be significant. Fifth, stay informed about changes and updates. Immigration policy can evolve quickly, and what is true today may change tomorrow. Follow reliable sources like US VisaPortal to get accurate, timely information about the reforms and how they are being implemented. Avoid relying on rumors or unverified information from social media, as this can lead to poor decisions. Sixth, if you are eligible for any of the new relief measures such as fee waivers or expedited processing, make sure you apply for them. Do not assume that you will automatically receive these benefits. You need to request them and provide the necessary documentation to support your request. Seventh, be patient but persistent. Even with the improvements, the immigration system is still complex and things do not always move as quickly as we would like. If you encounter delays or problems, do not give up. Follow up regularly with USCIS. Use the available tools to inquire about your case status and escalate issues if necessary. Your persistence can make a difference in getting your case resolved. Expanding on these steps, initiating filings now leverages the momentum of reforms, positioning applications in a more favorable processing environment, ensuring documentation completeness aligns with prioritization criteria, accelerating adjudication for prepared cases. Utilizing online tools empowers applicants with transparency and control, reducing uncertainty through direct engagement. Consulting attorneys provides tailored guidance, mitigating risks in complex scenarios, staying informed via trusted channels like US VisaPortal guards against misinformation, enabling informed decision-making, actively applying for eligible relief, ensures benefits are claimed, as automatic assumptions could lead to missed opportunities. Patience coupled with persistence navigates remaining complexities, turning proactive follow-ups into effective resolutions. Looking ahead, these January 2026 reforms represent a turning point for U.S. immigration. They signal a recognition that the current system has failed too many people and that change is necessary. While no reform is perfect and challenges will remain, these measures offer real hope and real relief for millions of immigrants and their families. Whether you are a skilled worker waiting for a green card, a family member hoping to reunite with loved ones, a student planning your future, or an asylum seeker looking for safety, these changes open new doors and create new possibilities. Here at US VisaPortal, we are committed to keeping you informed every step of the way. We will continue to bring you the latest updates, analysis, and practical guidance to help you navigate the U.S. immigration system successfully. Make sure you are subscribed to US VisaPortal and have notifications turned on so you never miss an important development. Give this video a thumbs up if you found it helpful and share it with anyone who might benefit from this information. The more people who know about these relief measures, the more people can take advantage of them. We also want to hear from you. Drop a comment below and let us know how these changes might affect your immigration journey. Are you hopeful about the reforms? Do you have questions about how they will work? What has your experience been with the immigration system? Share your story because your voice matters. And together we can support each other through this process. Thank you so much for watching US VisaPortal. Stay informed, stay hopeful, and remember that even when the immigration system seems impossible, there are always pathways forward for those who are prepared and persistent. We will continue to bring you the information and support you need to achieve your American dream. Until next time, Take care and keep moving forward on your immigration journey.